Good afternoon, ladies and gentlemen. This is the afternoon session of this panel of the Court of Appeals. For those of you who are not aware of this, there's 13 judges on the Court of Appeals, and over the next 2 days, we have been divided into panels of 3, and we're at various places over the state. And hopefully, if your case is being argued today, you're in the right place, because we'll do 2 cases and no more. And if you should have to go to someplace else, I'd say leave now. You might be able to get there. We will take up the cases in the order in which they appear on the docket. Each side gets 15 minutes because no any greater time has been allowed by our chief judge. The court has read your briefs, and we have received a pre-hearing memorandum from our research staff on each case, and we have read that. So we're familiar with the facts of the case, and we are familiar with the issues. And because 15 minutes is not very much time, I suggest that you get right to it. If there's something vital and important that we need to hear, do that earlier rather than later, because we don't want you to go away saying, oh, I wish it had just said that. Well, you might say that anyway, but at least I've given you a warning. It's my pleasure and honor to be seated on this panel because we have the most senior judge on our court and the most junior judge on the court. To my right is Judge Perrin. He has the senior status of our court. And to my left is Judge Schroeder, who is a newbie. And this is, in fact, his first set of oral arguments. And so far, he's done rather well. We haven't lost him this morning during the arguments. I want to say thank you to Anita Tebby and everybody that has worked with her to make this such a special time for the court. We appreciate this very much. We think it is part of the mission of the Court of Appeals is to get out of Topeka and come out and give people an opportunity to see the court in action, to see their own cases being argued, rather than have to travel to Topeka and see things that go on there. After the oral arguments today, we will entertain questions that you may have, and so we'll stay around for a while if anybody has any questions. If you don't have any questions and have to go to class, we understand that as well. But with one proviso, that we cannot talk about the cases, obviously, that we've heard here this afternoon. So if you or the attorneys wish to stay, the attorneys can't ask us questions. They'd like to, but we aren't going to answer them. But certainly any of the students are free to ask questions. All right, with that in mind, we'll take up the first case this afternoon, 106-002, State of Kansas versus Roy Wettrich. In 2010, a jury convicted Roy Wettrich of kidnapping, 2 counts of aggravated assault, felony possession of a firearm, possession of marijuana, violation of a protective order, intimidation of a witness, and domestic battery. Wettrich received a sentence of 124 months incarceration. On appeal, Wettrich challenges the district court's findings of fact and conclusions of law regarding an evidentiary ruling made during the trial. Wettrich is challenged to the scoring of a prior conviction in the pre-sentence investigation report as well. All right, counsel, you'd enter your appearance.
May I please court? Counsel, my name is Corey Call with Appellate Defender Office, and I'm representing Roy Wettrich. I would request 3 minutes for rebuttal, please.
3 minutes. You've got it.
Thank you. As the court said, Mr. Wettrich was convicted of several crimes, raised 2 issues today. I hope to get to both of them. but I'll take them in order unless the court has a different preference. We start with the evidentiary issue that the district court erred in denying the admission of a prior false allegation of the victim against Mr. Wettrick. The district court disallowed it under 6422D, which states that, I'll get it exactly right here, evidence of specific instances of his or her conduct relevant only as tending to prove a trait of his or her character shall be inadmissible. So that the argument was that this particular prior allegation goes to your credibility, and we do not allow specific instances of conduct to prove credibility. And generally, I think that's true. As this court noted in State v. Barber, however, there can be exceptions to that. In Barber, it was a prior allegation in a sex case, and they said that the defendant's right, the constitutional right to confront witnesses trumps the 6422.
If I recall correctly, in the Barber case, that was an accusation of sexual behavior with a minor, is that correct?
That's correct, that's correct.
And the minor had made a prior accusation of that conduct that proved to be false.
That I think certainly the defendant alleged it was false. I think there was a question of whether there was enough, but yes.
And the Barber court said in those types of cases, that fact that there was a prior false accusation could be admitted.
That's correct.
Now, my question to you, counsel, is that limited only to those types of cases?
Well, and that's the state's argument, is that those are sex cases, and sex cases are different. And I can't think of any reason, either statutorily, constitutionally, or logically, why you would separate out sex cases from other cases. 422 certainly has no language in there giving heightened or lessened scrutiny to sex cases. The right to confrontation, or the U.S. Constitution, doesn't provide extra protection for sex cases. And logically, it's still a false allegation. Now, I do think, when I was thinking about this case, I kept coming back to sort of 6455 as an analysis vehicle. And in 6455 cases, you've got prior crimes, which sometimes can come in under certain circumstances. But there's concern about those cases. I think the same thing's true here. And in those cases, the courts require that the prior incident be strikingly similar to the current one. And I think that's a reasonable approach, that you can't just bring in any false allegation. I think it has to be similar to the one at issue here, and sort of a relevance argument. But as far as the Barber court limiting it to that, I think they talk about those facts, but I can't think of any logical reason why sex cases are different based upon the statutes of the Constitution.
My next question to you, is this a false accusation?
Yes.
Explain that to me, please.
In the prior allegation, after this, the incidents for which he was arrested and eventually convicted, the victim, Ms. Galbraith, was talking to the police officers and to get a protection for abuse order. And the allegation in question is that she said that Mr. Wettrick wanted her to be a porn star. And so he invited his friend, Mr. Glasgow, over, held a gun to her head off camera, and then forced her to perform oral sex on Mr. Glasgow. And then at trial, they wanted to question her about this, because then that story somewhat fell apart. And
Well, you wanted to question her by the use of a photograph.
He did. He wanted to use the photograph, and I didn't raise that issue because, as I understood her testimony, even before, Mr. Wettrick held the gun off camera, and so then I didn't see the relevance of a picture that didn't show the gun. As I understood, that's why they wanted to admit it, to show that it didn't show the gun. I didn't raise the admission of the picture as an issue. So and that's what they wanted to do. But they also wanted to talk to her about this allegation and the fact that before she had said that he had held the gun and he was waving around. And you get to trial it was out of the hearing of the jury. They had a colloquy with her. And
we know it's a false allegation because the photograph didn't show it was a gun?
Not at all. Not at all. We know it's a false allegation because in the initial allegation, she said that he held the gun in the room. There was one movie with Mr. Glasgow, and he held the gun outside the camera before he forced her at gunpoint to perform that act. When she got on trial, she said that there were several movies and that Mr. Wettrick never held the gun in front of any witnesses, certainly not in front of Mr. Glasgow. And generally, as I read the record, that the gun allegation is that he often beat her, he often held a gun to her head, she was generally afraid of him, she was in an abusive relationship, and so she did what he told her to do, which is fundamentally different from a specific instance where he held a gun to my head and threatened him, like in this case. That's why it's a false allegation.
Now, when questioned on this, she, if I understand correctly, gave a series of "I don't recall." He had threatened me with a gun before, yes? Question, that's not my question. Answer, I don't recall. Isn't it true you told the police he put a gun to your head and made you do it? Answer, I don't recall, I don't remember. Question, if you told the police that he put a gun to your head and threatened you to do that, that is not true, yes? Answer, I don't remember. If you told the police he held a gun to your head and made you have sex with Louis Glasgow, that is not true? Answer, I don't remember. Where does that get us?
Well, there's 2 points, I think. First, let me say, she specifically said that Mr. Glasgow didn't hold the gun, that Mr. Wettrick didn't hold the gun in front of Mr. Glasgow, which contradicted her prior statement. She also specifically said that there was more than one film made, which contradicted her statement before. The other thing I would say is that even if you have a couple of instances where you were forced at gunpoint, where you performed oral sex on somebody because you were forced at gunpoint, I think that's memorable. I think there is a point at which the statement that I don't remember if that happened or not is so uncredible or incredible that it becomes a reasonable probability of falsity, which is what Barber requires here.
Now, all of this was done clearly outside the presence.
Absolutely, yeah, no, this was done
outside the presence of the jury.
That's right, yes. So yeah, there's no prejudice there. Procedurally, we're fine here. So if we find, this court finds error, then we move to the harmless error standpoint, the harmless error question. And the state, there's a line in the state's brief where they say constitutional arguments cannot be raised for the first time on appeal. And I believe that this was adequately raised below. And this comes from Barber, and so it's a little tricky. I'm not sure I understand. But the argument below was, we want to cross-examine this woman based on this false allegation. And they never said, we have a right under the Sixth Amendment Confrontation Clause to cross-examine this woman based on false allegation. But I'm not sure this court is, I'm not aware of this court ever requiring those sort of magic words. You have to make the argument, allow the jury to consider it. So I think it's been adequately preserved. And so we're looking at a constitutional question, which under Ward is a reasonable possibility that the verdict would have been different. And this case was largely a he said, she said type of case. There was, I think the stone on the state side would be that a friend of the victim's came over afterwards and they went upstairs and the victim showed her the gun and then told her the story. But that's still, I think generally the impact is, this is the story. And so you have Mr. Wettrick saying this didn't happen, you have the victim saying this did happen. And if you have a prior similar allegation, which the jury doesn't believe, that casts serious doubt on her credibility, which casts, there's a reasonable possibility that the verdict would have been different.
Well, wasn't she cross-examined, though? And didn't they ask questions about previous happenings?
Absolutely. And
well, then didn't he get what he asked for in terms of questioning her about these previous charges?
Well, maybe I misunderstood your first question, and maybe I conceded too quickly. I don't believe they were able to ask questions about the fact that she made false statements to the police about when he held a gun to her head. I think they talked to her about that she's in this abusive relationship, that she does a lot of drugs, a lot of those kind of things. So I don't think they got to the specific point of whether or not she had previously made false allegations, which is that's a serious ding in your credibility. Compared to the fact that you're a drug user, that you have these other sort of problems with your memory or the story changes, these type of things. I think that's why it makes a difference.
Well, she said, I don't remember a lot of times. And doesn't that give the defendant what he asked for? Because she's not going to say, yes, for sure, it happened. She just says, I don't remember it.
Right, and I think it's, and that certainly, it does help the defendant. I think it's different if after the incident, she's talking to the police officer and she says specifically, this is what happened. And then later she says, I don't remember that. And I think that's a little bit different situation. That, again, you've got the false allegation versus, I don't remember what happened.
Counsel, you're about out of time, but I wanted you to at least talk about the second issue, and that is, are you stopped from raising this Missouri conviction?
No, we're not. There was a prior Missouri conviction that had in a previous case of Mr. Wettrick's had been determined to be a person felony. He wanted to challenge that. And in the previous case, it turns out that they had held a hearing and the judge had made a ruling. The statutes specifically allow that if a criminal history has previously been judicially determined that, or previously been established, then you're not stopped. The burden shifts to the defendant to bear the burden of proof. And that's what the legislature said. And in fact, in the state's brief, they cite to the legislative research, if I can find this real quick, that says that the reason they amended it was a specific situation where an offender's prior criminal history was either admitted by the offender or judicially determined by the preponderance of the evidence. And it seems to me that what the judge and the state are trying to say is that a decision on the merits for collateral estoppel purposes is, does each side fight it? I don't think that's true. I think if the judge says, which normally happens most of the time, have you read the PSI? Yes. Do you have any objection to that? No. Defendant, do you agree with that? Yes. And then he finds a criminal history, then that's on the merits.
What relief are you asking for then on this point?
Well, it's Mr. Wettrick's burden to prove, and he was not allowed to prove. I don't think we can say what his criminal history is. I think this court remands it. You have a hearing where Mr. Wettrick will bear the burden of proving that the Missouri burglary is not a person felony.
What was the evidence presented by the state to uphold their burden of proof?
Well, I think what the state, I believe, presented a prior journal entry from the previous court, and even
Is this a Missouri court or
this is a Kansas court that determined that it was a person felony in a prior case. I think a journal entry, and there were some notes that there was a hearing. So the state, I think, met its burden of proving that it had previously been judicially determined to be C, and therefore the burden now shifts to Mr. Wettrick, which he was not allowed to. The state points out in its brief that there were some things submitted on the record, but I would note that the defense counsel tried to address the merits. The state stopped and said, I think we need to address the estoppel issue first. And the judge said, yeah, I think that's right. You're stopped. So Mr. Wettrick was never given the opportunity to fully present his evidence.
Thank you, counsel.
Thank you very much.
You still have your rebuttal time.
Thank you very much, Your Honor.
May it please the court, the state appears by Stephen Obermeyer. With regard to the first issue, I would like to point out a couple of things. The first deals with whether these prior allegations were indeed false, and the fact that the victim testified that she could not remember whether this gun had actually been placed at her head or not. The defendant argues that's an admission that the event did not occur, and I don't think that's the status of the law, that's the situation.
If a witness says, I don't remember, is that an admission?
I don't think it is.
What is it? I mean, it's just, I don't remember, isn't it? Can't we just have to take it at face value.
Correct.
It's not proof of anything.
I don't think that it is. It's certainly not an admission.
Is it tantamount to a denial of the prior statement? And should we treat it as such?
I don't think, I haven't found any cases where that is the case, where it's treated as such, a failure to recall an answer that that's somehow an admission.
I mean, I shouldn't say it, but it was the Nixon defense, wasn't it? I don't remember, I didn't know that at that time, that sort of thing.
Right. And here I think the judge how this case is different from Barber in one issue is a threshold determination of probability of falsity, that we don't really have that in this case. And Judge Welch did not.
Let me ask you this.
Okay.
Has any case applied the Barber ruling in a non-sex crime case?
I don't think so, no. I cited an unpublished opinion in the blue brief appendix where it states it does not apply Barber to non-sex cases.
But there is no decision saying this only applies to sex cases, correct?
Well, I'm looking at the language of Barber. Barber seems to say that because it says in sex offense cases, credibility is a central issue. The Barber court cites a case from Oregon in reaching its conclusion that the restrictions in 6422D in a sex crime case, the victim/complaining witness may be cross-examined about prior false accusations, and if she denies it, the defendant may put on evidence of those accusations. And I guess in Barber, they were satisfied that there was a reasonable probability of falsity on those cases. But
Well, isn't this case, though, based on a credibility weighing by the jury? He says it didn't happen, she said it did.
yes, it would be.
So I don't really see any difference between Barber and this case. I mean, in sex cases, oftentimes it is a question of credibility, but in other crimes it can be also.
That is true, but I had not found a case where this had been applied to other cases. And really,
Did you try real hard?
well, I found the unpublished case where they said it only applies to sex crimes cases.
It doesn't say it only applies to sex crime cases, does it? Doesn't it say it does apply to sex crime cases?
Yes, they applied it to sex crime cases. The district court allowed Wettrick to present evidence of reputation evidence or opinion evidence, which is another way to prove impeachment. Because what we're really saying under Barber is, forget what the statute says. We're going to do what we want to do. If the statute says you can't get into specific instances of misconduct, then it's unconstitutional, I guess, and we can't go into that. We can have these mini trials on whether the he said, she said about prior instances are true or not, and let the jury ferret all that out. And there's a good discussion in State versus Penn, which is another court of appeals case where social workers were not allowed to testify concerning the child's specific instances of conduct or misconduct. And Judge Welch read the Penn case and followed Penn, and that was the Penn case and 6422D were the two reasons for denying that evidence.
Well, all of this was done in the context of the admission of a photograph of her engaged in oral sexual relations with somebody who wasn't her. What does that have to do with anything in issues of this particular case?
I think it was just an attack to say she's a bad person or doing these bad things, so don't believe her. But I don't know that, but yeah, I agree. What is the relevance to that? We've gone kind of far afield to what happened here, where there is corroborating evidence from witnesses who arrive shortly after she is assaulted, and they see the gun upstairs in the bedroom, a friend does, and there's other corroborating testimony. So to the extent that the standard of review is abuse of discretion, a reasonable person would agree with Judge Welch in that ruling. As to the second issue on the criminal history, I would direct the court's attention to the motion challenging criminal history information. It's at page 218 of volume 1. And basically, they cited the version of KSA 214715 that did not have the 2009 amendments after State versus Shall. I had the experience of having argued Shall in the Court of Appeals. I think I prevailed. Went to the Supreme Court, and I don't know what I'm talking about. They reversed me. Fine. And the issue was, whose burden is it when you have a prior PSI? And the Shall Supreme Court said it's the state's burden even if you have a prior case. So we go to the legislature in 2009 and add some language to deal with Shall, because if you have a prior PSI where you agreed with that, why are we contesting it later? So the language that was added, which is not cited in their motion to challenge criminal history, is if the offender later challenges such offender's criminal history, which has been previously established, the burden of proof shall shift to the offender to prove such offender's criminal history by preponderance of the evidence. In that case, that would generally be Wettrick. But what Judge Welch found was that there had been a prior contested hearing on criminal history in 2006 in a criminal case, and the Missouri burglary conviction was determined to be a person felony. And so,
And that determination was made by a Kansas court.
yes, under collateral estoppel. So that was the reason for that, that ruling. And again, I think Judge Welch correctly applied collateral estoppel to that. If there had not been collateral estoppel, then Wettrick would have had the burden to prove that his criminal history was wrong because he had a prior case.
So under your view, if one district judge says that Missouri conviction is not a person felony, or is a person felony, so it adds to the severity level of the Kansas felony for which you have been convicted, correct?
Yes.
And that determines it for time, that point thereon. The defendant, cannot challenge that from that point on in that court or in any subsequent case. Is that correct?
I think so.
Based upon collateral estoppel.
Yes, because it was judicially.
Why do we have now the language that says the burden shifts to the defendant to prove otherwise?
Because the facts in Shao were that Shao had a prior PSI that he didn't argue with the accuracy of it. So in this previous case. So then we get to Shao's second case, and the argument's made, well, it's already been determined in a prior PSI. We don't have to redo this. And the Supreme Court said, yes, he gets to do it because it was not, there was not a hearing on
I
it.
understand. And so then the legislature changed the law.
Correct.
And said, once it's judicially determined, they could have said, once it's judicially determined, you can't ever raise the issue again. They didn't say that. They said, well, if you're going to challenge it, the burden shifts to the defendant to show why it isn't valid. Is that the status of the law now?
Well, the status is that it says if the criminal history has been previously established.
Which is what happened here.
It was after a hearing, yes, it was.
It was
Yeah.
determined after a hearing here in some other court, probably in Johnson County, some other division.
Right.
And the defendant lost. And so now why wouldn't the burden just now shift to him if he challenges it again?
Well, I don't think that amendment was intended to overrule the.
Doctrine of collateral estoppel?
Yes. But.
Because the argument that's being made by your opposing counsel is not the fact that it hasn't been denied in a prior case. It's he didn't have a chance to prove otherwise. And so I specifically asked him what relief he asked for. And he said, vacate the sentence and send it back and give us an opportunity to disprove that. And you're saying, well, you can't do that because it's already raised judicata. Same parties, state of Kansas, and the defendant, same issue.
Right. And I had tried to get the the Missouri docket sheet and journal entry added. I talked with trial counsel, and I'm not sure she was able to locate it, but yeah, if the court decides that collateral estoppel does not apply, then it would be his burden to show that that's not a person felony. And I guess in every other hearing thereafter, he can still raise that issue, even if he loses.
But he has to present proof because the state has no burden.
Right, right. So for those reasons, I would ask the court to affirm the convictions and the sentence.
Thank you.
Thank you.
Your Honor, I just have one brief point. I heard Mr. Obermeyer at the end of his argument say that there was no abuse of discretion here, and I don't believe that's the correct standard of review. The question is, does 422D apply? I'm talking about the first issue, that there was a false allegation. Is that excluded under that statute, which requires this court to interpret that statute, which is a de novo review. If this court says that it does, that 422 does not apply, and then you're deciding should this have been admissible, then there's no discretion to the district court because the district court didn't make those rulings. So there's no deference to be given to that decision. So it's all de novo at this point for this court. I just want to clarify that.
I want you to speak to the second issue if I can, because I'm having difficulty getting to reconcile the doctrine of collateral estoppel with the amendment to the statute that says burden shifts to the defendant.
Yeah, and I think the legislature specifically altered the collateral estoppel. Now, I suppose if this court says they can't do that, then that would be, you would find that section of the statute unconstitutional under a separation of powers doctrine. Is that? I guess that would be how it would work. But I'm not aware of this court or the
Well, you
Supreme.
certainly haven't argued that in your brief.
Oh, I wouldn't argue that at all. But no, I wouldn't argue I think it's absolutely constitutional. But I think that's the only way that, if they're in conflict, if this court says, well, the legislature can't do that. Because I think the legislative history, the plain language of the statute indicates that the legislature intended a situation where the parties litigated this, the judge made a decision, and here's what happens next time. That's a collateral estoppel situation. And so they specifically said, this is what happens. Now, if this court says, legislature can't do that, I think the only way you get there is by saying it's unconstitutional in the separation of powers, which I don't think is true, and I wouldn't argue, and I don't want you to do. But I think if you're going to do it, that's the path you take. Let's go down.
Thank you, counsel.
Thank you very much.
All right. Our final case today is State of Kansas versus Scott Edward Tilson, number 108253. Officer Lucas Sitton stopped Scott Edward Tilson, who was walking alongside a road at approximately 3 a.m. Sitton was searching for Tilson, whose vehicle had just been involved in a hit-and-run accident. A friend of Tilson had previously made a report that Tilson told her he was going to hurt himself. The district court denied Tilson's motion to suppress the evidence obtained from the stop. And that matter is appealed to us. Counsel?
Court Darrell Smith appearing with the appellant, Mr. Tilson. Judge, the court touched briefly on the facts. I'd like to expand on those a little bit.
Certainly, but do you want time for rebuttal?
Yes, Judge, I'd like to reserve 3 minutes for rebuttal.
You've got it. Proceed.
In this case, the accident that the court referred to occurred at College in 69. It's kind of fitting that we're having this here because we're very close to the actual location of this accident and the stop.
You're right over here somewhere?
Right over that way somewhere. The accident occurred, the call came in by Officer Sitton's testimony at approximately 3:30. Now, the phone call that you referred to from Brittany Davis was, according to her in her cell phone records, between 3:12 and 3:22 in the morning. Then there's the accident that Officer Sitton did
Now,
not
this
go
was a
to.
call that she made that she was concerned that he was going to hurt himself because he had told her he was going to hurt himself in the car or something. Is that correct?
She said that she got a call from Mr. Tilson, and she called 911 with that information, that she was concerned about the driver of this car. Then the car was located at the accident at approximately 3:30. Now, depending upon Officer Sitton's testimony and his time estimates, 5, 8, 10 minutes at the outside later, he stops Mr. Tilson at the area of College and Antioch,
Which would be further east?
which is a mile and a half approximately from the testimony at trial, yes, to the east of this location. A mile and a half by the roads, over a mile as the crow flies on Google Maps, and we discussed that in the trial. Now, Officer Sitton testifies that he sees him walking down the street, yells Scott. This person turns, looks at him, and keeps walking. At that point, he lights him up.
And by that you mean
By lighting
he
him
turns on his emergency flashers.
That vernacular term, yeah, as the court's pointed out, is
Thank you for that clarification.
at that point the stop of a citizen occurred, yes. Officer Sitton, I think that his testimony is critical, obviously, in what he didn't have. And coming to the standard of review in this case, I want to address that briefly. The standard of review is that the court in cases such as this give great deference to the trial court, to their factual findings, and then review the constitutionality of the stop. A couple of things that merit great deference in Judge Reddick's finding is, one, that Judge Reddick finds at the conclusion of the motion to suppress that this yelling of the name and a person glancing and going on, that's a non sequitur in this case. Simply, anyone would, I mean, somebody yelled Steve at me and I turned and looked and went on. Same thing. It's not a fact that really matters in this case. Additionally, one of the things that Judge Reddick finds,
Wait a minute, couldn't it be at least somewhat probative if a person's name is called out and they react to it? You know, if I was walking along and they said, "Hey, Steve," I might not turn around because it's not my name.
well, I think if that's a police officer and at 3 in the morning yelling and you're walking down the street, I'd take issue with the fact that you might not at least look. But that being said, I think given what Judge Reddick said about those particular facts, the court's entitled to give great deference to the fact that he said it didn't matter. Additionally, he said there aren't a lot of facts in this case. That's exactly true. There aren't. What you've got is an accident, a mile and a half away by road, a person being stopped, walking down the street. Officer Sitton's testimony is that person is walking normally. There's nothing unusual about that. He's simply walking down the street, a young man in the area of a college.
Now, once he gets close to him and sees the blood on his shirt, does it change then?
Judge, it's quite clear from the record in Officer Sitton's testimony that that was not until after he had stopped him, till after that stop had happened.
That's my point. He had stopped him and he came up and saw the blood. Does that change the scenario for you?
Actually, I dispute that in this particular case because of the photographs themselves, which I don't think are important to this court's determination. But we're talking about droplets that were never tested, and it's actually very difficult to tell from the photographs if they even were blood.
And this was 3 a.m. in the morning,
It was.
and he was looking for someone who a citizen called in, a concern. He said, "This guy is threatening to hurt himself." And I don't know, I think if Sitton hadn't done what he did, we would find him in dereliction of duty.
There is nothing connecting this person walking down the street to that car wreck 1.5 miles away. If the court takes that viewpoint, what you're essentially doing, I think, is doing exactly what the Ragnoni case warns us against, which is eviscerating the protections of the Fourth Amendment. If you take that, then anybody who could reasonably be within range, I guess running range, because the officers in this case joked about how he would have had to really book it to get that far away. And let's change the facts. What if it was an hour later? Does that throw your net all the way around the city? Because anyone who could be, conceivably within 10 miles of that area, if it's 5 miles of that area, if it's an hour later.
Well, that's not what we're dealing with here, though.
We're dealing with 1.5 hours away and stopping somebody simply for walking down the street. Officer Sitton had no description. He had a name. He had no description of this person, no descriptive indicators. He simply saw somebody walking down the street and stopped him.
And was the only person who was out walking, of course at 3 a.m., that's hardly to be wondered at. He was looking for someone. Here's a person, the only person who apparently is out walking, and it's not like he runs over and throws the guy down and handcuffs him. He goes over to him to try and find out, who he is, what he is. Is he the person who's threatening suicide, or is it someone else? I can't see anything unreasonable about that, which is the capstone of the Fourth Amendment. Was it reasonable or was it not? And to me, it looks very reasonable.
He calls a name.
Right.
This person turns and looks and keeps walking, which indicates that he does not want to be stopped. It's very clear that a stop occurred from that point. It is also very clear, to quote Officer Sitton, "I really didn't have anything until I stopped him and sat him down." That's Officer Sitton's facts.
Counsel, you're familiar with our case, City of Topeka versus Grabowskis. That's the case where the police officer stopped the two girls because they were looking for runaway girls. Stopped the two girls and talked to them, even though they didn't match the identity, and we said that was perfectly all right as a public safety stop, didn't we?
In this case, there is no identity. They have no description. It's
They
simply...
have a name.
We have a name, which indicates, I suppose, that since it's Scott, that it was a male. And that's all it would indicate. And he
I
yells
thought they
Scott.
had Scott Tillman. I thought they had the second name.
Well,
Or am I mistaken?
Officer Sitton had both names, I believe, and he yelled the first name. Okay? But if you say that just having a name entitles you to stop anyone within a radius of this area, then how big is that radius going to be?
Well, there's a difference, is there not, in the law concerning public safety stops, which police officers are allowed to make, as opposed to an investigatory stop. In other words, if you're looking for a bank robber, that's a different situation than if you're looking for two runaway girls.
And I think the Ragnoni case addresses that, Judge, when it says courts must employ careful scrutiny in applying the public safety rationale. That's exactly what this court has to do with this case, is look for the objective, specific, and articulable facts that there was clear, urgent, and immediate peril to this person. Those things do not exist in this case, and if you apply that careful scrutiny that the Ragnoni case calls for, there is no reason to stop him. You don't have to look beyond Officer Sitton's testimony.
Now, we know that Tillman's car was on its top back college and somewhere.
1.5 miles away.
And we've got an individual walking uphill from I think it's uphill, because I just came this way when I drove here to the college. It's certainly going downhill, it seemed like to me, coming this way. But anyway, and it's 3 a.m. or thereabouts, and he's got blood on him.
The blood was not part of this case until after the stop. And in Judge Ruddick's findings, nothing matters after the stop. And that should be what the court employs. That was not a factor, and I'm not prepared to argue it because it's really not a factor, and it shouldn't be a factor. It doesn't matter, as Judge Ruddick stated, because it's after the stop. The blood itself, and again, going into it, it's hardly discernible in this case. But beyond that, Judge, when you were noticing whether it was uphill or not, I'm sure you noticed there was a college in the area, and in college areas, it's probably not that unusual for young men to be walking around late. The only facts that they had, and again, to go over what Officer Sitton said, the only facts that they had were simply, there's a car wreck, 3:30, a mile and a half away, 8 minutes later, there's a person walking down the street. In applying that careful scrutiny that the Ragnoni case warns us about, you'd have to find that they could stop any person within walking, or I suppose running distance from an accident. And if they're running, I think that would probably shift this from a public safety stop.
To an investigative stop?
Yes. Coming back to my original point about the court's standard of review in this case regarding the facts, the stop itself, you don't have to guess about the stop. You can see that on the video. You can see not only what Judge Ruddick saw, but what Officer Sitton saw. And again, the objective, specific, and articulable facts that the state seems to think aren't necessary for this court are simply not present. What you've got is a guy walking down the street. There's a couple of red herring facts that I don't want the court to, and I don't want to run over, Your Honor.
Well, I'll tell you what, why don't you finish your remarks, and I'll still give you your 3-minute rebuttal.
Judge, with respect to a couple of red herring facts in this case, one is there was a pinging of the cell phone. The cell phone was
What
not...
does that mean? I didn't know. I read that in the brief. What does that mean? Pinging.
Pinging. There's a tower, and they can tell what tower that the cell phone pings off of. These towers cover a huge area. The cell phone in this case was actually in the car. It had nothing to do with Mr. Tilson. It's pinging off the same tower there as it would have been if it were on Mr. Tilson or if it were miles away.
So it could have been 25 miles, 25 mile circumference. I don't know.
I don't know what the radius is of a cell phone tower, but it's considerable. And yes, in answer to your question, it could have been much, much further away, and that's a red herring fact.
I thought the pinging was off of 3 towers.
Pinging?
I thought that came off a triangulation of 3 towers to give a location.
I may defer to the court on that technical information, but even as such, the pinging doesn't lend anything to this case because the pinging off of that phone was off of a phone that was in the car.
It wasn't on his person.
It was not.
What was your second red herring?
The actual name itself. And I think the yelling of the name, him turning and walking on. Judge Ruddick found that was an important fact. This court should give deference to that. But beyond that, it simply is a red herring, that it doesn't have anything to do. The only facts that matter in this stop were simply he stopped somebody just for walking down the street.
Yeah, but I guess my underlying problem with that is the officer was out trying to do a public safety to find this individual, and he sees somebody at 3 o'clock in the morning walking down a busy street in Kansas City after an accident. Wouldn't it be common sense to make the stop to see if that's somebody else or the person they're looking for, just so that they can conclude the search?
An accident a mile and a half away, 5 to 8 minutes previously, and if you adopt that, could they...
Do we have the exact time of the accident?
We have...
I don't get that from the record. We know when the police found it, but we don't know when the accident actually occurred, do we?
We know from the testimony that she said the phone call ended at 3:22, and we know that the officers were dispatched at 3:30. So I think within minutes we know what that time was. Getting back to your point, Judge Schroeder, if they were able to stop anybody for anything within a mile and a half and 5 minutes or 8 minutes from an accident, And again, the officers joke about how maybe he couldn't even get here that fast. What you're saying is you can stop anyone because they have no indicators about this person, no description, nothing. They simply have a name.
Thank you, counsel. I'll still give you a couple of minutes on rebuttal, since
Thank you.
we asked you that.
May it please the court, the state appears by Stephen Obermeyer. As far as the timing of this, I found in the transcript that the girlfriend's 10-minute call ended at 3:22 a.m. That he had left 87th Street, was getting on the highway, and she was concerned whether he was suicidal or not. So from 87th Street and let's say I-35 to 69 and 435, a police officer would know that may not take that long to get there. And if she's calling, and the call ends at 3:22 a.m., and so who knows when the accident actually occurred, but we do know that at about 3:30 a.m., Scott Tilson is the only person in the area of Antioch and College Boulevard where there's no other foot traffic around within, and I thought it was, the testimony was a mile to a mile and a quarter from the accident scene where he was seen walking after having wrecked his car on the highway and left the scene. The officer testified that
But the officer was going not to investigate the car wreck, but he was going to find Tillman, correct?
yes,
Is that what I
His-
got correctly?
his
from the
primary concern was to find the person potentially trying to hurt himself.
record? Now, did the officer know of the overturned car?
I think so.
And was the officer aware that it was Tillman's overturned car?
I think the license came back to his name, and I think the officer at least knew his first name as being Scott.
Now, obviously, the officer knew of the 911 call.
Correct, was aware of the 911 call.
So the officer is dispatched with the duty of finding Scott Tillman so he wouldn't hurt himself.
Correct. And I think we've seen that in other cases. The Grabowskis case, as the court referenced, where the two female pedestrians were stopped, even though they bore little resemblance to the runaway girls. And the Ragnoni case, where the ex-wife indicated that Ragnoni was suicidal, and 3 days later, he stopped in his car that's spotted. And the community caretaking function of the police was affirmed in those cases.
How far could this man have walked in 3 days? I guess he. So your argument is if we followed Ragnoni, the passage of time between the 911 call and the officer exercising a public safety stop is really immaterial until the reason for the call has been satisfied. Is that correct? Is that what Ragnoni teaches us? Because
Yes,
it was 3 days later.
Right, it was 3 days later. And here we have from the calls made at 3:12 to 3:22, and then around 3:30 is when his car's, or when he's seen.
In the Grabowskis case, they stopped two girls that didn't resemble the runaway girls. And the panel of this court said that was all right.
Right. And I think that gets to the purpose behind the public safety stop and the community caretaking purpose. And
Well, what about the situation with the blood? Mr. Smith argues that there's not much blood here. I mean, what's your view on that?
well, I think the testimony was within a minute after the defendant is lit up, as Mr. Smith called it. The officer noticed blood on his hands and clothing. At that point, he's already been
The stop's already been
Right,
effectuated.
the stop's already occurred, but it's, at that point, the officer's certain that this, I think the officer's certain this is the person that he's been looking for that was potentially suicidal, and they can follow that up and check it out. And so that's why the case is captioned State versus Tilson instead of Estate of Tilson versus Overland Park Police Department. Because why would you not want to pursue a claim of a suicidal person? Not just, you know, that they're thinking about it, they've wrecked their car. So we're looking for somebody in the area at 3:30 in the morning, and here's this, you know, sole pedestrian with no other foot traffic. And Mr. Smith is saying, you can't stop that person to see if he's the potentially suicidal driver. I don't think that's what the public safety stop, what the purpose of it is, and that Judge Ruddick got it right when he denied the motion to suppress.
Now, Judge Ruddick also said that the calling out of the name really wasn't controlling here, and he turned. What's your view of that?
Well, I guess the standard is substantial competent evidence. That didn't weigh with Judge Ruddick a whole lot.
Well, it really doesn't prove much, doesn't it? I mean, if you were walking along at 3 a.m. and somebody pulls up behind you and yells, "Scott," wouldn't you be turning your head to see what caused the noise and who was talking anyway, whether it was your name or not that was being called? Wouldn't a cautious individual?
Yes, that might be. And here the officer said Scott, and his name was Scott, and he turned.
So it may not prove that was his name, but he did hear him. We can
Right.
say it proved that.
Right.
But I can see the judge's viewpoint on that, why it's not determinative of the issue.
But I think in looking at all the other factors, as these cases often turn on, especially the 3:30 in the morning with no other foot traffic, and you have him in the area. As far as his cell phone had pinged to the general area, I'm not sure how far apart those cell phone towers operate, but there's sure a lot of them down 435. I don't think it's for 10 or 15 miles that the cell tower's, you know, going to be pinging off of that tower. But
At least in terms of our record, that wasn't determinative of the district court's decision, was it?
I don't think it
The
was.
pinging?
Right, but it was one of the factors Officer Sitton was aware of when he's looking for this.
Quite frankly, we always learn much from these, and that's the first time I'd ever heard of that pinging, that the police can ping my cell phone. I suppose that's reassuring.
Counsel, my main thought on this is that it appears from the record that the officer was for sure, no kidding, just concerned about the well-being of Scott. That there was no thought of investigating a crime or anything like that. Is that would you say that's a correct reading of the record, at least from your standpoint?
Well, I looked at Volume 3, page 13, Judge Perrin, and saw that I thought he testified that his primary concern was to find the person who was potentially trying to hurt himself. And then he testified that the minor point at hand was it was a hit-and-run accident, but the major issue at hand was we need to find an individual if he's trying to hurt himself. So there was that undertone of also the getting away from the accident, which might explain how Tilson got from point A to point B pretty fast to get away from that. But Officer Sitton his main purpose was to find the person potentially trying to hurt himself. For those reasons, he went to trial on DUI and driving while suspended and leaving the scene of an accident. He was acquitted of the DUI and convicted of the driving while suspended and leaving the scene of the accident. So those are the two convictions that I would ask you to affirm. Thank you.
Mr. Smith, I'll give you a couple of minutes. How'd that be?
Thank you, Your Honor. I'd like to briefly address something that Judge Perrin pointed out, that the benevolent Officer Sitton was only there to investigate for safety purposes. As Mr. Obermeyer pointed out, this was an accident where it was apparent, and my client was convicted of leaving the scene of the accident. Now, to think that the officer didn't have those underpinnings, that they're also investigating a crime, I think that is something that simply flies in the face of the facts. And that's exactly why the Ragnoni case warns us that the court must look with scrutiny at these cases when you go mixing these apples and oranges between public safety and constitutional stops and the constitutionality of stops for crimes, because there is that temptation on the part of law enforcement to mix those apples and oranges and do exactly what the Ragnoni case argues against, and that's eviscerating the constitutional protections of the Fourth Amendment.
So Ragnoni, they stopped him 3 days after the report.
The thing about Ragnoni that I think differentiates it from this case is that they knew it was Mr. Ragnoni. They suicidal, Mr. Ragnoni. That isn't the case here. They had a name, and they stopped someone walking down the street a mile and a half away. Somebody who, and I'd like to quote what Judge Ruddick said with respect to that name. He didn't acknowledge his name. He just kept walking. You know, the fact that he doesn't acknowledge his name isn't a fact that cuts in their favor. I'm assuming he's referring to the state. They didn't have an indication that this was him or an indication that he was in danger. The phone call saying a person may be in danger doesn't link this person walking down the street. And that's
You
what
have
I
sight on
argued
that.
to Judge Ruddick.
Do you have sight on that?
Judge,
I thought he did react to his name.
he did react to his name.
He turned his head.
And I may have been looking at this while the court was talking, but he did turn to his head.
Well, but turning his head, did he react to the sound or did he react to his name?
I don't
Would you,
know.
if you were walking along at 3 a.m. and somebody called out to you after, over behind you, wouldn't you not turn your head whether it was your name or not? Seems to me rather logical, just to see who's calling out.
And I think I may have misquoted what Judge Ruddick said. I'd like to get to that.
All right.
And specifically, page 14 in the court's findings of the motion to suppress. He yells, "Scott." Mr. Tilson turns around. Well, does that mean that's Scott Tilson, or does it mean he's just looking to see why he's yelling this strange name? I don't know. And at that point, Judge Ruddick says, continue contact based on all the facts. There were no facts beyond that. And Judge Ruddick didn't find any other facts beyond that. There's simply a name yelling, somebody turning and looking, and he keeps walking on.
Thank you, counsel. Appreciate it. Well, that concludes our hearing for Johnson County Community College. I was instructed in the elevator this morning as we were coming up from the parking garage, this is not a junior college. Do not call it a junior college. It is a community college. Well, no matter what you call it, it's a splendid institution, and we thank everybody for having us here to hold our hearings. And if you have questions, again, we cannot talk about the cases that we've heard here today, even though I have, and I'll talk to Ms. Tebby about this, but we will send copies of our opinions when we render them to her. And so if you're interested in finding out the rest of the story, then you get in touch with her in due course. So because I can never predict when these things will filter out of our opinion mill. So if you have any questions, we'll be glad to answer them at this time. If none,
Wait a minute, give him a minute. I do judge. There has to be a few. I disagree.
uh-oh, she sounds, this sounds official now. There has to be a few questions.
Go for it, Liz. So with, and I know you can't speak about the case, but with just IT moving so fast, our communication devices moving so do you find the need to be a little bit more learned about technology? It's certainly not the way it was 10 years ago.
Would you like to answer that, Judge? Yeah,
Well, as my kids could tell you, I'm almost helpless before a lot of the new technology. Yes, of course. I mean, and I'd be a little worried about a judge who doesn't know anything about DNA, you know? I'd say, why, you know?
I did not know about pinging.
And that's why I brought that up.
In my defense, I did. And I understand that pinging can put the phone within a certain number of feet,
We can't talk about the case, but
but not,
can't talk about technology. I
but the
guess.
technology is there.
That's why we have learned people on the court to make up for deficiencies such as mine on, because I thought pinging was something else. All right. Any other questions? Graham?
Is there a certain amount of time when they have to make a decision in these cases?
We like to render our decisions within 60 days. They don't get any easier with the passage of time. It's not like good cheese that increases in flavor with the passage of time. And remember, with this docket, next month, we'll be in 3 different panels, going to different places with different judges, and we'll have 30 cases to deal in that docket. So we can't fall behind. If we do, we get covered up. So we have to get it done.
The opinions may very well be done in 2 or 3 weeks from the standpoint of our having decided them and a judge having written an opinion. But there is a production process where it circulates through the court, goes through the reporter's office, and heads off toward reproduction. Although sometimes, it's usually over 30 days, that's not because we're sitting on it for 30 days. It's because that there are some unavoidable technical things that have to be worked out before they can be presented.
The clerk's office and the reporter's office are very meticulous about fact-checking. If we state in an opinion that a red 1975 GMAC pickup was involved in a car accident, they will go through the record to verify that it was a red GMAC pickup 1975 as the year. They verify all of that facts, and that takes some time to do all of that. They also verify all quotations from legal authorities. They also verify the citations to that. So that's all takes some time once the opinion is done, especially if we're publishing the case.
I think I saw some hands over here, 1 or 2 more.
Okay?
I was just wondering, I'm sure there are times in an appeals case where you have heard different attorneys speak who are maybe not as prepared as some. I just want to know if their preparedness has much of an impact on your viewpoint of the strength of their case and how.
An ill-prepared attorney is ill-prepared to defend or help their client, and will often harm their client's best interests because they're ill-prepared. We have been extraordinarily lucky in this docket with having very good counsel, very well prepared. Now, I say that while they're still here, but I would tell that to them in person because all of these attorneys have appeared before us before. They know what to expect. They're not rookies, so they know what they're doing. They're the paid professionals, and God bless them because they help us in making our decisions.
A long time ago, some years ago, the Court of Appeals was what we called hot court, and the Supreme Court was what we called cold court, as far as preparation before the arguments. Is that still the case, or has there been a shift?
Well, we've had a lot of Court of Appeals judges go up to the Supreme Court, and so it's now a hot court.
Well, some of us like to think of them as a warmer court than what they used to be. But you've got to understand, we hear a lot more cases in a year than they do. So we have to be prepared to ask questions. Remember, their timing, they're allowed, under their rules, each side gets 30 minutes. And so they'll go for a week. When they finally hold court, they'll go for a week and hear cases every day, maybe 4 in the morning, 4 in the afternoon. So those are long opinions, long cases. And sometimes they're more prepared than they used to be. Obviously, way back when dinosaurs roamed the earth, and I argued a case in front of the Kansas Supreme Court, it was obvious that one of the justices was aware of the facts of the case, and that was common then, that one justice had been assigned the case to be aware of the facts of the case and had studied on the law of the case, and the others had not. Because typically then, it was at their conference, usually held a couple of weeks later, that they would have prepared. So that was the Cole Court. We can't do business that way. We have to prepare ahead of time, ask counsel questions. You heard, Judge Perrin's favorite thing is to ask a question before they even give their name, just to see if they're ready, that sort of thing. So we're hotter, and they're getting warmer.
Of course, we have superb people working as research attorneys for us, and they help out a great deal too.
Got one of mine's right back there. Raise your hand, Kevin. He's one of my.
I see a familiar face or two out there, yes.
And is Andy Mayo here today?
He was here this morning, but he left.
We encourage them to come to the arguments because, they get to see the people who are making the arguments in the briefs, and that's important for their training too. Yes, sir, right here.
I have a question about the research attorneys. How much leeway do you give them in their sort of pre-hearing research to come up with alternative or newer arguments than those that are just briefed?
That's a real good question. They have total freedom in my chambers. That is not the case with all of the judges on our court. There are some of the judges that are a little more strict that say, you shall not deviate from the issues that have been presented in the briefs. Now, primarily, let me advise you that that is not to say that we want them to argue a position. If they want to, and it's not uncommon for them to group issues that have been made by the parties into a larger group so they can address it all in one fashion, that's not uncommon, and that's more efficient because they've got a time limit too on how long that they have to make their pre-hearing memorandum for us.
My research attorney has been with me for a long time, and so he knows the way I go on a lot of the more common issues. But, once or twice a month, he'll come in and plop down and say, well, Judge, here's one reason why you get paid the big bucks. And we'll then lay out a case and ask what I think about it. And I'll tell him what I think about it, but I always presume that he will process it and he will give me what he thinks is the right answer. Now, we don't necessarily agree with our research attorneys all the time, but I would say I agree with them about 90% of the time because of our scope of review and the fact that they've been able to look at both briefs and their dog isn't in the fight, and they just are trying to give us an honest evaluation of it. So that helps us a whole lot.
The great benefit that I get from a pre-hearing memorandum is the fact that they delve into the record, and if somebody says in a brief that this is what the record reveals, and if they indicate that it doesn't reveal that, that's dynamite. That's something that we need to know, and because that's, shall we say, a great material for asking questions.
Somebody's going to walk with a limp after that, You don't ever want to you don't ever want to lie to the court. For one thing, it's too easy to figure out what happened.
Why don't you join me in thanking the Kansas Court of Appeals for coming on campus?
And have us back anytime.
Thank you, Your Honor.
Thank
Please
you.
rise.